Welcome to Business Success Tips, where you learn to make more money in less time and have a lot more fun. My name's Paul Sanneman. I'm founder of Contractor Staffing Source, where we help contractors build great teams. My guests today are Jason and Wes from Frost Brown Todd. Everybody's favorite subject, attorneys. We all love this, right? The necessary evil of the construction industry. No, that you guys are evil, but you get it, right? It's like, oh boy, my attorney called me. I'm so excited.
Right. So nobody ever.
Yes, right. So the issue is, I've been, coaching forever, like 40, 50 years, and I've had most of my experience with attorneys has been not good because it's after the problem. Like, what'll happen is somebody. I'll give you a typical example. One of my clients calls me and goes, well, my client's not going to pay me the last $150,000 he owes me. And I go, why? He says, well, he has an attorney, and according to California law, my contract didn't have blah, 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 and this didn't happen, and he doesn't have to pay me. And the truth was, his client's attorney was better than his attorney, and he lost 150 grand. Like, oops, right? Because he didn't have something in his contract that he knew he should have had. So usually legal problems, preventative, are fairly cheap. Once they go to court, it's always expensive, never cheap.
Absolutely.
So I guess one of the questions I'd have, if you're a little contractor, like 2-3 guys, you and a couple million, do you need to even have an attorney look over your stuff, or can you wait until you get sued? Wes?
Our answer to that would be, Paul, you always want to have an attorney looking over your paper at least once. And that doesn't mean it has to be a very expensive deep dive, but you ought to have at least your attorney take a look at it to fly spec it to make sure that there are not any major gaps that you could drive a truck through, right? When you're engaging with attorneys, you want to be upfront with them and say, hey, look, we just want to have a cursory review of this document. Please let us know if you see anything major. And then ask them to kind of scope out the cost of the work. Jason and I are happy to do that. We always talk to our clients on the front end about what the cost and the scope of the work is going to be, so that everyone goes into the project knowing exactly what the high end of their legal spend could possibly be. But we always try to be more efficient and effective than that to kind of control their legal spend. But we always, an ounce of prevention is always worth a pound of cure, because you're right, Paul. Once it gets into court, it's out of control and the costs skyrocket exponentially. So again, we like to see it a little bit on the front end. If it's 2 guys in a truck, look, we know that. We know we don't want to strangle your business with legal bills. We'll be judicious in how we operate and what we do. But it's always best to have someone look at your paper before it's out there in the wild and you're exposed and you don't even know it.
So your paper is changing with AI. People are saying, write me a contract, and it's not perfect, but it's better than trying to do it yourself, right? So how does that, let's say you have an agreement, like some kind of, contract you have with your client on, payment, a construction contract. And you go to 𝗬𝗪 and say, write me a construction contract, and it does something, whatever it does. We didn't have that before, which I think is a good thing. But do they, once they have the AI write it, do they send it to you and say, where are the holes? Does it make any sense? How does that work these days? Because things have changed, definitely.
Jason's a little more AI savvy than I am. Leading out with an AI-driven contract can be both good and bad. I mean, it depends on which AI function you're using. If it's more contract savvy than others, some of them will spit out horrible contracts, to be quite frank, and we have to redo the whole thing. Some of them are a little more adept and prone to drafting a better contract than others. Does it help us? Yes. I mean, it takes the ball, to the red zone, so to speak. It will not ultimately replace the role of a lawyer, because you still have judgment calls to make. There are still things that probably any AI software is not going to pick up, that Jason and I, through 35 years of combined experience in doing this, are going to know should be in that document. But it can help. It can certainly defray some legal spend, some costs, but it's not the end all be all. And I would not suggest even still going to market with your paper without, again, having a lawyer look at it at least for 30 minutes to an hour just to fly spec it. I defer to Jason a little bit more on that.
And Jason, that would say, for example, do you have any AIs that are better, like 𝗪𝗓 or, there's like 5 or 6 out there that are better at writing contracts? You must know, because everybody uses AI now, including attorneys. So Jason, do you have any comment on that? What's your favorite contract writing AI?
So we don't really use it to write contracts, but I have been sent contracts from clients that they've used AI. They haven't told me that outright, but some of them have kind of after the fact come out and said, yeah, I did use AI to write this, but you can kind of tell. We use 𝗘𝗽𝗶𝘀 at our firm, and the best thing about that is that it pulls from our forms that we've, curated over, like Wes said, 35 years of combined experience, where it really is more of a time saver, whereas I don't have to look for specific language like the AI software. I can describe what I'm looking for, and it'll say, hey, in this document, this is similar language that you use. And instead of like, if I didn't get one word specifically perfect in a search query, I wouldn't have, in past years, I wouldn't have gotten the correct document back. But here I can just kind of, word search, and I can get back what I'm looking for in, minutes instead of, or really seconds instead of minutes. And so it really helps us kind of find what we're looking for to tailor to each situation. And it does kind of give you an easier starting point it gives you a starting point quicker than having to, spin your wheels trying to find where to start from.
So what are the typical documents? I mean, obviously a contractor needs a contract with the, his to do the work. So he needs a construction contract with his, clients. He might need a contract with his employees if he has an employment agreement, right, with his employees. And then maybe he needs a buy-sell with his partner or whatever. So what are the typical documents that let's say, pick a number, a $3 million remodeling company needs?
Yeah, so Paul, to answer that, it's a little specific to whatever the circumstance is that we're dealing with, but let's just kind of take it maybe from the top down or the inside out, so to speak. Let's call it inside out, right? So let's just say you're set up as a corporation or an LLC. We typically roll out LLCs these days because it has the best of both worlds as far as liability protection and pass-through tax treatment. So you're going to want an operating agreement that typically governs governs the internal workings of your business. And if you have partners, typically you work through your business deal with your partners through your operating agreement. So an operating agreement is a primary document that you're going to work through that governs the interior of your business as between you and your business partners. Jason and I do those all the time. We have a bang up tax team that's really good at drafting operating agreements and thinking through those life issues that impact your business, death, divorce, things of that nature, estate planning issues that you might come through, buy sell if one partner wants out. Those are very important documents to think through and sit down and talk about with your partners. I would not leave that to AI to figure out for you, because that is so life specific that AI is not going to get close to what you want in that regard.
And there can be major management decisions that specific, people or partners should be involved in or should not be involved in, that this is the exact document that would contain those sort of management.
So for example, if you have a corporation or an LLC, somebody has to write the original corporate documents, right? For a C Corp or an S Corp or an LLC, right?
Yeah, I mean, the document that actually forms the company, articles of organization, certificate of formation, that's pretty rote stuff. If you're getting into the operating agreement, however, that's what governs the day-to-day affairs, the buy-sell arrangements, things of that nature, which are fairly bespoke to the current situation of that founder and his partners or her partners. That kind of stuff you can't just really pull down off the shelf and nail it. You've really got to sit down with your attorneys and think about, what is our business? What are we trying to accomplish here? What could realistically happen? Is my partner older? Could that person pass? What happens when that partner...
Well, now, one interesting thing is the most expensive thing I've ever seen happen in construction firms is a divorce. We talk about what's really expensive, right? So depending on the state, I mean, is your spouse automatically your business partner or not? Are they part of the corporation? How does that work? Because I know a lot of guys find out and women find out too late, like, oh, I didn't know that she owned half the company or he owned half the company because of some California marriage, whatever law, joint
Yeah.
custody property or something, like a kid, right? I didn't know that was true.
Yeah. And so there again, AI, can kind of help you, but you really kind of need your lawyer to tell you, are you sitting in California, which is a community property state, or are you sitting in another state that is not community property? Because if it is community property state, then your wife or your spouse or your husband and whatever it may be may own 50% of everything that you're building, and it's unbeknownst to you. And so that's why you really need to consult with a lawyer when you're going through these things to understand your particular situation based upon where you reside geographically, but also like what is your business reality that you're trying to map out your legal documents for, right? So that's those internal operating agreements. It's going to take a little more time and money, but you need to nail them and get them right, because you're right, Paul. You have a divorce and all of a sudden you're dealing with someone's spouse, and now you got a business partner that you didn't bargain for. Life can get difficult if you haven't mapped it out in your operating agreement on the front end.
Right. I'm sure you've had that happen one side or the other, right?
Yeah. I mean, we're literally, let's just call it it's not a landscaping business, but let's call it a landscaping business. We've got an owner that's going through a divorce. They want to sell the business, but they can't until they deal with the divorce and figure out who's actually going to own the business, who's their next business partner within the business. It's kind of made it a mess. And so, yeah, you want to make the rules of the road very clear in your operating agreement. What happens when someone dies, someone gets divorced, someone goes through a bankruptcy, someone wants out, buy, sell rights. There's a myriad of issues that you got to work through on the front end to avoid a bunch of issues on the back end.
So I know it's hard to give a cost, but a lot of people don't call attorneys because they're expensive. I mean,
Yep.
That's just, to me, if I say, well, why don't you have an attorney? Well, I don't need an attorney. They used to say, I don't have anything. And now they say, AI did it for me. But it's like, it's changed probably in the last couple of years. It went from nothing to AI doing it, which is probably better than nothing. But most small business people figure, well, I'm not big enough to need an attorney, or I'm insured. That's always, I've got liability insurance, everything is covered, right? And it was interesting. I was talking to in a podcast the other day. Someone has an AI thing that goes out and checks all your subcontractors to make sure they're covered, because people lie, right? And so
Sure.
You have 30 subcontractors, and very few people actually go out and physically look at the documents of all their subcontractors. They, quote, take their word for it. Or the subcontractor could take a picture of an old document that's not invalid anymore, change the dates, and send it to you and say, I'm covered. And then when somebody falls off a roof and you're getting sued for like $1 million, you go, I thought I was covered. No, he isn't covered. Then you get drug into the whole thing, right?
Right.
So I would say one thing you need to do is make sure not only you need to be covered, but don't all your subcontractors, they have all the right insurance and stuff, or you're liable, right?
You can be. I mean, so in the contracting world, legacy is a big issue, right? And so your company, your brand, your name is your legacy, and people protect that. Nobody likes to pay lawyers. We realize that. We realize that we're the last call that you really want to make. But if you want to protect your business, if you want to protect your legacy properly, you're going to have to spend a little bit of money on the front end to protect the back end. Now, Paul, you were kind of leading into like, what might a standard operating agreement cost? Again, right. I hate to give you a lawyer answer. It kind of depends on your facts and circumstances, but we're routinely doing those unless there's certain exotic features that you want built into your agreement. We can probably knock those out for around $5,000, maybe $10,000 at most, if you're like getting sophisticated and exotic. But they don't have to be any more difficult than you need them to be. But if you want to protect yourself, if you want to protect your family, if you want to protect your business and your partners, you need to spend a little bit of money on the front end to make sure that works properly, because I can promise you the headache and the pain that's coming when someone dies, or you're dealing with someone's spouse who you don't want to deal with, or someone's gone into the bankruptcy and now their creditors are coming after your business. You will pay dearly on the back end if you don't pay up front on the front end.
Right. Yeah, I think to answer it, to like kind of round out one of the questions you asked earlier, what other agreements do you need? I think that an employment agreement isn't a bad idea. a lot of people are at will states. So you can, even though you're at will employment, it would still behoove you to have agreements in place, not just for you, but for your employees too. So everyone knows what the expectations are, what that employee's duties are, what the compensation is. So there's no surprises for anybody. And then, Wes and I just worked on, in the last couple of weeks, the paperwork between yourself and the customer, whether it's a SOW, like a statement of work, or if it's like an actual full-blown agreement, making sure that the company's protected there, making sure there's adequate disclaimers for, if something goes wrong, if you're, doing landscape work and something goes wrong in the plumbing, that might go on, just to make sure that nothing that you or your business touch can get brought onto you, and that liability is somehow transferred to you, just to make sure that everything's disclaimed.
Well, litigation is the last thing anybody wants, but sometimes it's hard to avoid depending on the state and the people and all that kind of stuff. So now let's say you do like M&A stuff, right? Merger and acquisition. And that's happening a lot in the trades these days, private equity coming. Literally everybody's getting an offer once a week from some PE company to buy their, roofing business, right? Because there's a lot of cash. I think AI has disrupted a lot of places it used to go. And so there's hundreds of millions, billions probably saying, well, let's, I just talked about, I think I had 500 million. I want to buy some companies because I don't want to put it in, well, I used to put it in because AI is killing all that stuff. So I want to put it in like a plumbing company, something I know that AI is not going to disrupt in the next 5 years. So there's a ton of cash coming in. And unfortunately, most contractors are not very sophisticated when it comes to mergers and acquisitions. And so a lot of times they sign something they shouldn't. They go, oh, I didn't know. I thought I was signing this, but I'm signing that. I didn't want to call the attorney because it's going to cost me $500 an hour to talk to him. So I asked AI and I did this, and AI happened to be wrong. Oops, right? So how do you guys handle the M&A stuff? If I'm a company, I'm considering selling, I'm getting these offers weekly from somebody who wants to buy my company. How should I react to those? How does that work?
So at a general level, I would say, Jason and I have been seeing this a lot lately in the last year. We've been seeing buy-side shops, whether that's private equity or family offices or whomever, wealthy independent sponsors. They are approaching the contractors and trying to get them under LOI before the contractors get adequate representation. That's understandable.
LOI, explain LOI.
Yeah, an LOI is a letter of intent. It's certain parts of it are binding, most of it's not, but it's basically an agreement to buy your business on certain delineated terms that are set forth in that letter of intent. Most buy sides want to deal with the seller directly without the involvement of an advisor on the sell side, so that the buy side can get the terms that they want that are more favorable to them. We would recommend highly that you speak with an attorney before you ever sign any paper, an LOI, a non-disclosure agreement, an indication of interest, or an IOI, anything that revolves around a buy-sell process with a private equity firm or family office. You should always speak with an attorney first before you sign the paper. We always advise that. Whether the deal is big enough or not, you should also consider whether or not you should be represented by an investment bank on the sell side. Jason and I routinely work with investment bankers. They kind of stand in the gap and help maintain your enterprise value, your net working capital calculations, and they keep the deal moving in a timely, efficient manner. So we always suggest that our sellers consider either getting an investment bank or sometimes a broker if it's a smaller deal.
Now, what does an investment bank or broker do? They represent the seller, right?
They represent the seller and their economic interest in the deal. And the investment banker serves the purpose of, not that private equity firms or family offices aren't honest, but it's to keep them honest. It's to keep a healthy tension in the deal, to try and keep that enterprise value at the value that's set forth in the letter of intent. It's to keep the net working capital adjustment honest, after the closing. They serve as a check as against the buy side in order to kind of keep the deal terms as static to the LOI as absolutely possible. They're your business advisor in the transaction. Jason and I are your legal advisors in those transactions, and we work with the investment bank to get you the best deal with the most legal protection absolutely possible so that you have the most successful closing that you can possibly get.
Now, how does everybody get paid?
Jason, you want that one? Cash.
Yeah, normally, so when we represent sellers, I mean, normally we all get paid at closing. So, you know, our legal fees, if you engage a broker or a business advisor or investment banker, their legal fee or their, you know, their success fee. And then let's say you had a CPA firm or something that did some financial diligence or do some work on your end, kind of all the transaction fees, like the seller's transaction fees, are all paid at closing when the seller gets their money.
It's like buying a piece of property, everything's paid out of escrow at the end, right? Same kind of thing.
Yeah. So for the benefit of our viewers here, Paul, typically you have your purchase price at closing, right? Then they're going to take out of the purchase price at closing any debt that needs to be paid off at closing. So if your fleet, your equipment, whatever else is encumbered by debt,
your attorney's fees, just
yeah. So first is debt,
or
right?
your CPAs or the investment banks, all the people that have been running up the bill while you've been doing this.
No, we never do that. So so the first thing that gets paid is the debt, right? And so the buyers should pay that off for your seller client at closing.
Right.
They'll pay off your debt to get those assets unencumbered. Below that is your investment banking fee, your CPA fee, your attorney's fees for representing you in the deal, along with any transaction expenses. If you get a sell side 𝗬𝗃 as part of the transaction, if you have some other expenses, those will get paid off at closing. And then lastly, there might be an escrow or there might be a holdback to have proceeds readily available should there be an indemnification claim post-closing or should there be a net working capital dispute. Sometimes they'll hold that money back out of the purchase price. But part of Jason and I's job, and we went through this yesterday in another deal, is to make sure that prior to closing, our seller's not coming out of pocket paying these things off. This stuff comes out of closing proceeds, so you're not fronting these costs up front. They're
and what if it doesn't close? Does nobody get paid if it doesn't close? It falls out of escrow?
If it doesn't get paid at close, I can only speak for ourselves and our arrangements. Typically, Jason and I, as a goodwill gesture to our clients, will take a busted deal discount, right? And so and typically when we're costing out deals, Jason and I, we cost them out. We're not putting our clients on just an hourly clock and just running the clock. We have an in-depth conversation with our client before the deal ever starts to say, hey, look, this is what we think that this deal is going to cost. And Jason and I use what's called a fee not to exceed. So this is purely hypothetical. Let's say the deal, we think it's going to cost $1,000 in legal fees to do your transaction. If we only spend $800 in time and cost, we'll only bill you $800. If it lands on $1,000 on the head, we'll bill you $1,000 on the head. If it costs $2,000 to do the deal, we're only going to bill you $1,000. But Jason and I have those conversations up front before the deal ever starts so that both sides, us and the client, know exactly what we're getting into. Expectations are set, and the client knows from the outset, I'm only going to spend X number of dollars at most doing this transaction. If the deal doesn't close, we'll typically agree to a busted deal discount on the front end, call it 50%, 20%, whatever it may be. But if the deal doesn't close, we have families to feed and mouths to feed as well. Right. And we have bills to pay as well. So we got to get paid a little bit, but we will do our clients a solid and probably take a busted deal discount.
Now, as I'm looking, is there some minimum number? I mean, all the money's flying around, but it's like, unless you can get $1 million, $2 million, $3 million, there's got to be some, is it really worth it kind of number, right? I mean, you do these deals all the time. I mean, my guess is you're not going to get at least a couple million. It's sort of not worth it. Is that a number that makes some kind of sense?
This is clearly we were talking about the seller, not the attorneys, correct?
The seller, yeah, the seller.
Yeah, I mean,
no, you don't.
I solicit Jason's thoughts here too, but I think this is a little bit of art and science, right? It depends on where is the seller in life, right? Are they dying to get out of the business?
It's better than closing it down, or they might die or something, but that's
sure.
But sure. I'm saying there's some kinds of, I have a lot of clients, and to me, if it's not a couple million, it's like, why go through the hassle? It's just, right? It's a lot of pain and suffering.
Yeah, it's definitely a lot of hassle because, this is something that Wes and I deal with every day. But for a business owner, you're not used to going through an M&A process. So it is a lot of reading, a lot of due diligence, a lot of calls, a lot of stuff that you got to do that you're not used to doing that distracts you from operating your company.
Right.
So again, like another reason why to engage an investment bank, because they kind of help you through stuff, and good solid legal counsel, because they'll be able to kind of take some of that heavy lift off of your shoulders, but it's still, no matter what, is going to be outside of your bread and butter day-to-day stuff that you're used to doing. But I really, it really depends on each seller. I mean, if your revenue is like $100,000 a year, and that someone's going to offer you 10x multiple on your EBITDA, I mean, yeah, that's probably a pretty good deal.
Right.
But I mean, it really kind of depends. I can't give.
Well, what I've heard going around is that somewhere between 3 and 6x, 3 times 6 EBITDA is typical out there in these days for a decently run kind of business, right? I mean, roofing, plumbing, some kind of service business. Remodeling is as good because there's no recurring income and that kind of thing. That is, 𝗬𝗪 is pretty good at that part. What is my business worth? How would I say, so it's good at giving that kind of advice to make some kind of sense of it. So I would say that I know people listening to this are saying, well, it sounds good, but they're expensive. I know that's what people are saying. That's what I'm saying, right? It sounds good, but it's expensive. So how can people can they just call you and say, look, this is where I am. These are my issues. This is what's going on. How many ideas is this going to cost me? $2,000, $20,000? Because I think the reason people are afraid to call their attorney is because they're $500 an hour and they freak out, right? So is there some way that if you're listening to this podcast and you just don't know what you don't know, right? Most of these guys are way underrepresented. I guarantee it, because the last thing they want to call is their attorney. They don't call them until somebody sues them, then it's way too late, or they can't collect money, or an employee goes sideways. It's like when the ambulance, being an ambulance because something happened before they call you. So how do we get them to call you preventatively without freaking out about, oh my God, this is $500 an hour on the phone?
Sure. So let's kind of dive into this. Jason and our practice has kind of two main pillars. One is outside general counsel services. The other is kind of the buy, sell, exit strategy we've been talking about.
Right.
For our part, Jason and I are never going to coach you to do one thing or the other. We want to help you achieve your goals. If that's to scale and grow and operate, fantastic. We can serve as outside general counsel. If that's to prepare for a sale and ultimately exit, fantastic. We can help you sell your business. But we're going to defer to you as to what you want to do. We're not going to pressure you to sell. We're not going to pressure you to just to hold it and operate. We will do whatever it is that you want to do. Now, if you're unsure of what you want to do, or if you think you have a legal issue and you want to discuss it, or you just have questions, the way Jason and I operate is we're happy to take your phone call. We are not going to nickel and dime you to death. We want to hear from you. We want to know what's going on in your business. We do a lot of work off the clock to figure out what it is that we can do to help your business. And only before we have a conversation with you are we going to turn on the clock or start invoicing you. We're going to have a very full and frank discussion on the front end about what is the job, what do we think it's going to cost, and only after you approve it are we going to go on the clock and actually bill you. Otherwise, you're never going to call us. We want you to call us. We do not want to be prohibitive.
That's why people call attorneys, right? They go, ka-ching, I don't want to make this phone call, right?
Right. Not all attorneys operate that way, and that's fine. I mean, that's how people can operate however they want to operate. That's not how Jason and I operate. We want you to call us. We want to figure out if you have an issue, and if and only if you have an issue, then we will go on the clock to help you. But we're going to have that conversation up front so you know exactly what you're getting into, and there's not sticker shock on the back end.
So it's not going to cost anybody to call you guys and say, look, this is my situation. I'm going to buy, sell,
Absolutely
or
not.
I've got 5 employees. I've never had an attorney. I have a C Corp and that's about it. And I live in California. Am I in trouble if I get a divorce? I mean, just the kind of stuff everybody wants to ask questions about, but they're afraid it's going to cost them a lot of money to ask the question. So they never ask the question until it's too late.
Correct. No, we're not going to charge you for those conversations, because if we charged you for them, you're not going to call us, and we will never be able to help you. At the end of the day, Jason and I do what we do, and we work with contractors because we love working with them, we like working with them, and we want to help them. If our cost system is prohibitive of that, we're not going to be able to do what we set out to do in the first place, which is to help contractors. We want you to call us. We want you to email us. We are happy to have those conversations to figure out if you have an issue or if you don't. And if you do have an issue, we're going to have a conversation first where we scope out the job, price out the job, and you're going to have a decision to make. Do I want them to do that for me or not? And if not, that's fine. You're never going to get a bill from us. If you want us to do the legal work, then and only then will we do the legal work, and then and only then will you actually get billed for it.
Right. So I would say, if you're listening to this podcast, I'm sure most of you either don't have an attorney or only use one when you need it. And that's usually too late. So I would advise, most contractors do not have an attorney on retainer. I mean, it's just, they don't. They should, but they don't. Because they go, well, I don't need one unless I get sued. My insurance will cover it. And then they find out way too late. It's too late. So I would suggest, if you're a small guy or woman and you're, 2 to 10 million, whatever, and you don't know what you don't know, which is the scary part, and your only legal counsel has been AI, which is better than nothing. I would say, give Wes and Jason a call. You got literally nothing to lose. And whatever you're going to learn something for sure, right? And that's going to be valuable. So how do they get a hold of you guys if they like to do that?
Absolutely. And let me throw one other thing in there, Paul. Sometimes, even if you have an attorney, it's important that you have corporate attorneys like Jason and I, or deal attorneys like Jason and I, because if you're relying upon a litigator, and there's nothing against litigators, if you're relying upon a trust and estates lawyer, nothing against them either, they don't have the comprehensive view of your business and how all this works together in total like Jason and I do, because we're your outside quarterback for your entire business. So don't also fall into the trap of, well, I've got an attorney, but if it's a trust and estates attorney, that's a very narrow lane.
It's sort of the same problem with the CPA. I have my CPA, my CPA has 500 clients and one of them's a contractor. Yep. That's not a good CPA for a contractor.
We sit in the saddle, we sit in the foxhole with you and hold your hand, in the firefight. That's what we're there to do, and we're there to help you. You can email me at 𝗬𝗪_SCOTT, SCOTT at FBTlaw.com. So 𝗬SCOTT at FBTlaw.com, or call me at 901-277-3988, 901-277-3988, or text me and we'll get back to you within a day. I promise you.
Okay, cool. Thanks, guys.
And my email is 𝗪𝗪𝗍, BRACE at FBTlaw.com. And my cell is 615-969-4797. So call or text anytime.
So I would say the one thing you guys are going to do, if you're listening to this, you'll probably sleep better at night if you at least have one conversation, because we all have, what if kind of things going on in our head. Thanks, guys. I really appreciate your time. This has been very valuable.
Thank you, Paul. Much appreciated.
Thanks, Paul.